Hello, this is Matt on the Moon Family Sedan channel. A couple days or so ago, I published a video articulating that, well, yes, I'm just as ready for the SEC v. Ripple case to be over as the next guy. I was also making the case that where we are at right now, even though, yes, we would have loved to have this settled months ago, have Judge Torres come to a conclusion, the fact that she hasn't yet isn't some sort of indication that there's something nefarious at play here. It's not even outside the realm of what would be considered normal. But still, the question remains, why haven't we seen a conclusion yet? Because this is a bit longer than what you would expect specifically from Judge Torres based on her history. And also, if you look at the LBRY case, well, the LBRY case concluded much faster than the Ripple case. What gives? Well, I'll tell you this at the outset of the video. It has to do, in large part, to the amount of material that has to be considered by the judges in those cases. Ain't the same thing. So here's a headline from the Crypto Basic. Deaton highlights major difference between Ripple and LBRY lawsuits. But before going, before going further, I do want to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so a couple days ago, I tweeted out the following. I understand people are frustrated we've been dealing with this SEC lawsuit that harms XRP holders for over 2.5 years now. However, I can't relate with the idea Judge Torres is corrupt just because she hasn't issued a ruling yet. Timeline is within normal parameters. And by the way, I wasn't, although some were kind of skeptical, I get it. I wasn't kidding when I used the word corrupt. I kept seeing that word again and again and again. And I think it's a minority of people within our community, but I still see it a lot. And so there was somebody within our community named Mark who responded to me and said, I don't think anybody really is saying that she is herself corrupt. It's just our government is corrupt, so she's in the government. That's what I believe people are saying. Respectfully, I must say, Mark, not quite accurate. So I did respond to him, and nothing against him whatsoever. But I was just making my point here. No, people literally are saying that she's corrupt. And so I shared this screen grab in these comments that are on your screen in response to a video that I put out where, again, the one I was citing a couple days ago, I published having to do with the fact that yes, we want the case to be over, but it's within normal parameters. And I was fleshing out the concept in that video, and there's certainly people that think that, nope, there's actually corruption here. I don't see any evidence. I don't see them put forth any evidence, but they certainly. So somebody here, or actually, let me note this. I wrote back to Mark and I said, might want to reconsider that. Here's a small sample of back-to-back comments in response to one of my YouTube videos. Tons of people think corruption is at play with Judge Torres, and it's silly nonsense. Yeah, so no disrespect to anybody if you disagree. I'm just saying it does seem a little bit silly to me if you don't have evidence. That's a big, big, big claim. And so here somebody wrote to me on my video, if it gets past this Friday, I'm going to assume that the judge is fully corrupt. The very next comment from another person says, the judge is getting paid by the SEC 100%. No way it taking this long. So again, I don't see any evidence put forth. It's just people aren't getting what they want, which is the conclusion of the case, therefore nefarious intent. It's just the logic doesn't really follow. And then I also highlighted this. Former SEC attorney Mark Fagel wrote, and this is on June 23rd, and I'm just covering this real quick just to set the table a little bit. The average federal summary judgment ruling takes about 6 months. So there's nothing unusual here, and this is a more complex case than most. Yes, many of us have read the tea leaves and anticipated something sooner, but welcome to the reality of an overstressed legal system. XRP community member Sherry responded to that and wrote, thank you. I have been saying for a while now that the time frame of the case is normal. I have even gone as far as pointing out that criminal cases take priority and Torres has many. I might as well be talking to a wall. Sigh. And then Attorney Fagel responded and said, you know what you're talking about, and you're pretty much always right. That's not acceptable to crypto Twitter. Which brings us to why we are seeing the delay that we're seeing. And again, good reasons, as I said at the outset of the video. The cases are different. We shouldn't expect them to be exactly the same. And so here was the headline from the Crypto Basic. Deaton highlights major difference between Ripple and LBRY lawsuits. Attorney Deaton has highlighted the significant difference between the Ripple and LBRY lawsuits. Crypto law founder and pro-XRP attorney John Deaton recently called public attention to the major factors differentiating the Ripple and LBRY lawsuits. He made this known after a Ripple engineer pointed out that the build up to the summary judgment decision in the Ripple lawsuit is similar to the LBRY case. And in fact, let me just go to the thread so you can see everything that led up to this. XRP community member Mr. Huber, he seemed to not buy into the idea that the timeline that we've been seeing in the SEC v. Ripple case is normal. My understanding, I don't want to misrepresent it, but my understanding is that he believes it should have concluded some time ago. And I just respectfully disagree. Nothing against him whatsoever. We're all entitled to our opinions. I just happen to feel differently, that's all. And so he shared this screen grab. If he was doing some sort of search, you can see part of it at the top of the screen here. How long does a judge take? And then it kind of cuts off. But you can get the cut of his jib. He's trying to find out how long does it take for a judge typically? What's normal to decide on cases having to do with motions for summary judgment? And the answer that he got was 1 to 3 months. Now, if that were true in this particular setting, then I'd say, yeah, we're way past due. We're more than twice as far out as we should have, and there should have been a decision. Except for, according to attorney Mark Fagel, that's not quite accurate. And so attorney Fagel, former SEC attorney here again, wrote, "That's why it's best not to do legal research by Google search. That's some random fact from a law firm practicing personal injury law, presumably in state court. So no, that's not correct. For example, the most recent study of federal cases I saw, 2018, found that summary judgment motions in this particular federal district court take on average about 6 months, and Ripple is approaching 7 months." And so, folks, again, when we use the word average here, like understand that it could be, it will be, and almost certainly less or more than that. There's a very good chance anyway. So the fact that we're slightly longer than average isn't obscene. Yes, again, I'm with you. I want the damn thing over. I get the frustration that people are feeling, but being a little bit over that isn't outside of the norm. And so attorney John Deaton jumped in and responded to attorney Fagel, and Deaton said, "If federal district courts were averaging 1 to 3 months for potentially dispositive motions like summary judgment motions, Congress wouldn't have initiated the 6 months rule." And I know what he's referencing there. The 6 months rule, if you take a certain amount of time, let's just say subjectively to most, it would seem like a long time. You actually have to report that to Congress. That's my recollection here. I can't remember exactly what this was called, but there's some sort of law set, and then you get put on this list, and then it brings attention to you. And so judges, the theory is you avoid to not be on the list. So that's what he's referencing. I can't remember all the specifics, but that's the gist of it. Conceptually, I know that's what he's talking about. And then you have Ripple employee Neil Hartner respond here to attorney Deaton, and he is a senior staff software engineer working at Ripple on on-demand liquidity. So he's familiar with some stuff. Ripple employee Hartner says, "How long was the LBRY case from when motions were filed to summary judgment ruling?" And attorney Fagel responded, "About 4.5 months, I believe." Much less voluminous record there, however. Exactly. And that's what I was getting at the outset of the video. There are way more moving parts of this case, the SEC v. Ripple case. And so Ripple employee Hartner responded to him and said, "I recall people following the LBRY case thinking the judge was taking a long time and speculating that was a good sign for the defendant, which was a big nope. Volume of material to review seems like the only thing to read into the timing." Yeah, and I think that he's probably right about that. The only thing that I would say, as something drags out, I don't think that this speculation is terribly unreasonable, but it could just be the case that, at least the judge, if time passes, perhaps the judge isn't just rubber stamping one side or another. Maybe it's more like, okay, this is a display of, yes, very deep thinking here, but to assume that it would have been good for one side or the other, now with the benefit of hindsight, it looks like that obviously wasn't the case for the people that were thinking perhaps this really is good for LBRY. And this is where attorney Deaton jumped in, and he said the following: "The filings in Ripple are 10x the filings in LBRY. Remember, also, LBRY's counsel stipulated that prongs 1 and 2 were satisfied, and the only contested prong in the case was prong 3, which has a 2-part test. That's why some people say Howey is a 4-factor test." And in Ripple, Factor 2, Common Enterprise, is hotly contested. Also, the issue of consumptive intent, not even meeting Factor 1 because it's a non-investment, is in play. Yeah. So this case is very different. So there's a lot less to consider there for again, two primary reasons pointed out by Attorney Deaton. There was way less to review in the LBRY case, so it ended up being 4.5 months. Okay. Also, the judge didn't have to do any sort of in-depth analysis on the other prongs of the Howey test because LBRY, and this is probably a mistake, pretty obviously a mistake at this point, they ceded that ground in the LBRY case. There's just one prong to look at. I mean, they should have been pushing back on all the prongs. But as a result of that, though, there was less to consider. That's really all that's going on here. I don't see anything else. I don't see anything nefarious. There's assertions of corruption and stuff, but those are just assertions. There's nothing else to it. There's no meat on that bone. Now, if you have something, let me know. I would love to see it if you actually have evidence, but just the assertions being made, I think it's more so just a sign of frustration. And the frustration, again, I do think it's quite understandable, but let's just do our best to stay grounded in reality here because I think that what is most likely here is that justice shall be done. It doesn't mean that's a guarantee, and maybe you have to go to a higher court if Judge Torres really bungles this thing. But even if Ripple loses, and that's an if, it doesn't mean we're going to get some sort of disastrous outcome as it pertains to XRP specifically. In fact, if you look at what happened in the LBRY case, LBRY lost, and it looks like we're going to be getting a happy ending here because if you look back to that the court hearing in January, we now have the transcript public. It was made public in the last couple of weeks or so. We now know for sure. I mean, we knew because Deaton was delivering the message, but we now have written proof. The judge articulated, yes, secondary market transactions are not part of what's being considered in the ruling against LBRY. So if we get something like that in Ripple, even if it just comes at the remedies portion of the case, we should still be golden. You know. Now the question is, would that be enough for exchanges to relist? Well, I hope so. If not, that would be rather disappointing. But I mean, it's pretty clear that what the judge is saying here in the LBRY case, we'll have to see how they actually words in the final remedies portion of this, but still, I'm just saying. So, no, I don't think anything's bad or nefarious or pick your word. I don't think any of that stuff's happening here in the SEC v. Ripple case. And if you look at everything that's led us to this point with Judge Torres, if anything, I don't know how you could hold a position that things have been better for the SEC than Ripple and all the pretrial stuff. If anything, I think pretty reasonable amount of the rulings and decisions are in favor of Ripple and, as a result, XRP holders in many instances. In fact, that's the way that I look at it. I've been following this damn thing for over 2.5 years now. I think more frequently, Ripple got what they wanted than the SEC getting what they wanted in this case. So the good news is, regardless, this thing's about over. I don't pretend to know exactly when it's gonna finally conclude. Attorney Hogan has pointed out that normally you see, filings, any sort of filing in this case, occur on like Thursdays and Fridays. That's more probable. So if you're trying to figure out when might it occur, well, I don't have a date for you, although attorneys have made all sorts of predictions. So far, none have come to pass. But if you're just looking at what day of the week or filings typically made by the judge, well, according to him, Thursday and Friday. So every Thursday and Friday, get a little extra excited when you look at your phone or your computer or tablet in the morning, because there might be some news or interesting price action. I'll just say that. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.